This is Court Watch with Alex Sawyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Josh Blackman, a Supreme Court scholar and professor at South Texas College of Law. The justices returned to the bench earlier this month after their summer recess, and they announced they'll hear a dispute over laws out of Florida and Texas that crack down on social media companies and their censorship. They also just announced they'll take up a dispute over the Biden administration's communications with tech companies, allegedly pressuring the private companies to censor posts the government deemed disinformation. We'll talk with Josh about the social media disputes, including one the justices will hear next week about public officials and their capability of blocking people online. We're still waiting to find out if the justices will hear other disputes related to the FDA's approval of the abortion pill and whether a diversity admissions program at the high school level discriminates against Asian American students. Josh joined me to chat about what we make of these new developments. Hey, Josh, thanks for joining me to discuss the latest news on the Supreme Court. First, I just wanted to get some housekeeping things out of the way to update listeners. Correct me if I'm wrong, but I think we're still waiting on some interesting cert petitions. One is the FDA approval regarding the abortion pill. I don't think that they've said what they're doing with that one, have they?
No, that's not on the docket quite yet.
Yeah.
No, that's not there yet. It will come up at some point this year, but because the court had issued what's called a stay of the Fifth Circuit's ruling, the status quo is the same, and the abortion pill remains available.
Mm-hmm. And then I think the same is true with, we don't know what they're going to do with the Thomas Jefferson High School diversity case, right? Following the whole affirmative action ruling. I think that one has not been granted yet. Am I wrong?
That's right.
Okay,
that petition's still pending.
Yeah. So those are some ones I'm kind of keeping an eye out for. But I know earlier this month they returned after their recess, and you and I had touched base on some interesting cases that they were going to be hearing this term so far, at least we knew of. And one was the CFPB case, right, where they're deciding whether or not the funding structure is constitutional. The critics say, of course, that the CFPB doesn't get its appropriations from Congress annually. It goes straight to the Treasury, right? So I guess my question to you is, after listening to those oral arguments, it was very interesting, obviously, our former Solicitor General under the Trump administration arguing about the unconstitutionality of this funding structure versus the Biden administration saying, no, this is, historically, this is fine. There's been precedent here. I don't want to say who do you think did a better job, but which way do you think the justices were leaning? Who were they more open to?
I think the government's going to win this one, and that's not because of any, good or bad advocacy. I think the problem is that the Constitution has something called the appropriations clause, which says that money can only be spent if it's appropriated. Right, and at a basic level, that means the president can't spend money without Congress's permission. I think everyone agrees there. The harder question is, does the appropriations clause limit Congress's powers? And there's really been no Supreme Court decision on point ever holding that the appropriation clause limits Congress's powers. And I think even Justice Thomas and Justice Alito were struggling, trying to find something in the text to put a limit, but there really isn't one. The Fifth Circuit, I think, did the best job they could. So I think what's likely going to happen is that the government will win this one 8-1, or maybe even 7-2, or maybe even 9-0. It might not be close. But I think Noel Francisco did about as good of a job as he could. But it's just, there's only so many things that the lawyer can do with a case.
Right. And I know even for the Thomases and Alito, I think the Biden administration was able to point to, I don't know what it was, I should pull up my notes, but it was the immigration, something customs board or something. I don't know. There was some department that, looking back towards the founding, that didn't necessarily get appropriations from Congress annually too. So they had some historic precedent, which, that side of the court likes.
Right. That's the customs service that has been around, and these are agencies that collected fees from people, and there was no some sort of fixed appropriation from Congress. So I think that if the government wants, there's going to be an ample amount of authority. If the court wants, there's an ample amount of authority that can cite to put restrictions on the agency.
Mm-hmm. So we don't think the CFPB is going anywhere, but I do think that there's some there's just, I have an interesting kind of umbrella question for you on social media. It seems like this court, tell me if I'm wrong, but the Roberts Court seems to be dealing with a lot of social media disputes, at least now, and are willing to kind of dive into that wild west of the internet. And so one of the things that we know that they're going to look into is, I think it was state laws out of Texas and Florida that had aimed to restrict like social media companies and their censorship. I know the Florida one was definitely geared towards like not suspending politicians' accounts, that sort of thing. Then we also have a big case that was just granted this earlier, I think it was earlier this month, last week. On Friday, the justices said that they're going to hear that dispute with the Biden administration, allegedly, or I guess it's pretty detailed in lower court rulings, their communications with social media companies and wanting to pressure them, I guess, to take down certain posts, I guess, mostly related to what they said were misinformation about COVID-19 in the 2020 election. So I know those are like big cases that that haven't been scheduled, but we're going to have on the docket. And then also, of course, they're going to hear one next week over public officials and their ability to like block people on their social media accounts, their personal accounts. I guess my umbrella question to you is the Roberts Court now the one, I mean, is this their focus? Is some of their big cases taking on the internet and like free speech rights? Because I feel like we dealt also with, they kind of also did the Carpenter ruling, right? Which wasn't necessarily speech related, but, you know, tracking of cell phone data. It just seems like they're kind of doing the new digital age frontier.
Yeah, and don't forget last year we had a case involving Twitter and YouTube, and whether they can be sued for basically promoting Al-Qaeda and ISIS, you know, terrorist videos. I think your question, Alex, is exactly right. In recent years, the courts had a heavy share of social media cases, and I think a lot of it turns on this idea of what exactly is social media. Are these, just sort of startup tech companies that should be given latitude? Are these important market players that exercise significant power over our discourse? Or are these even perhaps almost like utilities, organizations that can be regulated the same way the phone company was regulated back in the day. Sort of compounding this on top of the cases you mentioned is the idea of net neutrality. This has been around since the Obama years, it seems, my entire adult life. And now the Biden administration is trying to bring back the net neutrality rules that were scuttled by the Trump administration, that were adopted by the Obama administration, that were rejected by the Bush administration. So it's just this never-ending back and forth. But I think you're exactly right. Social media and these sort of tech companies seem to keep being drawn in because of their significant market power. And I think people want the court to jump in.
Yeah, I think that some people see it as like the new public square, right? Like you don't really go down to your sidewalk, and that's not really where you hear from your leaders, right? You kind of look at them you hear from them on their social media accounts and have the right to, I guess, debate there. But on that same topic, we will have maybe a further guidance from the court, because next week they do hear, I think it's 2 cases that deal with public officials and their use of their private social media accounts and then blocking people, right? I think one was someone that was blocked because they kept commenting. It was during the pandemic on COVID issues. And I guess it's basically kind of a clash of First Amendment rights. Like you have the public officials who say it's their private account. They have, their ability to post as they want and have people who they want to see it. And then on the flip side, you have, I guess, residents who say, I have a First Amendment right to be able to view these and see and need to have like updates from my leaders. Where do you think the court will come down? Do you think there's going to be a way for them to draw kind of a line on this? And do you think President Trump is kind of hanging in the balance here? Because we know he was big on using social media, still is. And then, of course, there was lower court rulings regarding him and blocking people.
Well, you're exactly right. This is actually all about Trump, as I suppose most things are. As people probably recall, during the Trump years, the president would often block people on social media who said bad things about him. Yeah, I mean, they would block people on Twitter who would say bad things about him. This went through the courts, and it was argued that Trump is actually violating the First Amendment rights of people to communicate with their elected officials. Because, if you block someone on Twitter, they can't see your tweets. If you block someone on Facebook, they can't see your posts and the like. It sort of went up to the Supreme Court, and by the time the justice had the case, Trump was out of office. Mm-hmm. So it kind of fizzled out.
Right.
But the issue will still sort of percolate for the foreseeable future, because then you have these other officials. You have school board members and sheriffs and the like, who again are blocking people for various usages.
Mm-hmm.
And I think what we're actually seeing is that the court is sort of dealing with this issue. Now, again, there's two types of free speech claims here, right? There's the right of the citizen to communicate with their elected representative and on their Facebook page. There's also the right of the politicians to sort of curate their message and to show what they want. So I think they're really First Amendment issues sort of on both sides of this case. But the sort of the first and foremost issue is even blocking what's called state action. In other words, when you block someone on social media, are you doing that in your capacity as a government official, pursuant to some sort of statutory authority, or are you doing this as a campaign official trying to run for re-election? Because people who are in a public office are always running for re-election as well. So I think that the court will probably just hold that the blocking is not actually state action, so the First Amendment is not implicated.
I guess that could also, it's interesting to me, like, the idea that when you talk about state action, like there's some of these accounts that they run as in their official capacity, right? But versus like the idea of like having a private Facebook account. Do you think the court will have to go in and say, well, even though it's your private Facebook account, like you use it as a public official? Like, do you think there's going to be some sort of test?
The test for whether something's state action is sort of tricky. The citizens, the people posting, have said whenever a government official does something that's related to the job, it's good enough. And the other side said, well, when something's done pursuant to a statute, that is, a statute says, as part of your job, you must post on social media, that would have to be required. I think that test is probably close to what the court will do, maybe something in between. But there will have to be a space between what people do in their government capacity and what they're doing to run for election.
Mm-hmm. Do you think this is going to be one of those ones that we see like an ideological breakdown?
No, this may not be obvious left-right, because I think even the court's liberals may be sort of leery about punishing politicians who have, trolls putting all this garbage on their pages.
Mm-hmm. Speaking of like the First Amendment, so there's also a case the following day next week that will be argued, and it's a trademark dispute, and it's over the phrase "Trump too small." And I guess there's, correct me if I'm wrong on the facts, it's been a while since I've looked at the petition, but there's a man who wanted to trademark that phrase, but there's a federal law that basically says if to use somebody, a public official's name, you have to have permission. Is that correct?
Yeah, no, this is right. This is kind of like a funny case.
Well, I just like that the Biden administration is trying to say you can't trademark the phrase "Trump too small." I know
right.
that
so the origin of this case is going to be canceled. During the 2016 campaign, if you recall, Marco Rubio, who was the candidate, made a comment about how Trump has tiny hands.
Mm-hmm.
I don't know why he said it, but he said it. And then Trump, during one of the debates, said, "My hands aren't small. Look how big my hands are." And he's just holding up his hands like how big they are. It's just, it's sort of insane stuff.
But yet it's ending up in the Supreme Court.
Yeah. So, and then a guy said, "I have an idea. Let me make a T-shirt with the slogan "Trump too small," and it's actually a little. This is radio, but he was actually holding up his fingers like putting his thumb and forefinger about an inch apart, because it was very small.
Mm-hmm.
And he tried to trademark that. Under the Lanham Act, which governs trademarks, there's a provision that says you can't use a living person's name without their consent. And actually it says even more, if you're trying to use a president's name, you must get his widow's consent if his widow's still alive. So it basically limits your ability to use the names of living people. Now, it's not about criticism, but as a practical matter, no one's going to approve a trademark that's critical of a person. So it kind of censors on one side.
Mm-hmm.
Then again, there's nothing stopping you from making a T-shirt with a slogan without any sort of trademark. You only need a trademark to get protections. In fact, the trademark reduces speech, because I can't make a Trump too small T-shirt if there's a trademark on it. So this is actually a case that's not obvious about viewpoint discrimination. It's not obviously about any sort of targeting based on content, but the effect of it is to basically condition a government benefit, a trademark, on the basis of the speech. And so it does have a censoring component, which is why, as you noted, it's sort of funny the Biden administration is defending Trump on this one, but Trump's not really involved in the case.
Mm-hmm. Well, I guess the fact that it's kind of political speech, I mean, does that have any weight here or impact? I know political speech can be treated even more protected, right?
Right. I mean, so in effect, this affects political speech in this case, but the statute has nothing to do with politics. Even if I just put, Alex Sawyer or some other random name on a T-shirt, even though I guess you're a public figure, kind of, but if I put a random person's name, the statute would apply exactly the same.
Mm-hmm. I guess even if it was trademarked, and this guy could come after anyone using it in the political sense, like if someone wanted to use it protesting, would that be protected? I mean, there seems like there's so many different, like you said, it could restrict other people's ability to use it. I don't know. I guess it just seems like there's a flip side to that, right? Like if it's not trademarked, more people would have a right to engage in this.
Yeah, so the free speech arguments here are not obvious. I think they cut actually both ways.
Mm-hmm. I think it's going to be interesting, and this is also one I don't know if there's a clear like left-right divide either.
No, I don't think there is. Right. Again, I don't know how the justices line up in this case.
Yeah, how have they? I mean, they've kind of been very like, if you recall, remember the Tam case. The Slants, the band that wanted to trademark.
Yeah, Metal v. Tam.
Yeah.
Exactly.
So that was kind of different though, because it was, I guess they said it was like the government was being able to look at trademark applications and say whether they were disparaging, and it was like a viewpoint thing. But here you made the interesting point that like this could even be like a phrase that's complimentary to somebody, but they'd still have to get permission, right? It doesn't have to just be critical. So it's not necessarily viewpoint discrimination.
Yeah, the statute itself has no viewpoint discrimination, but in practice, in effect, it will have viewpoint discrimination.
Mm-hmm. Yeah. So I don't know. That one's going to be interesting to follow too. There is a case that's coming up. It's not next week. It's the following week. I believe it's going to be November 7th. It's the Rahimi case. And you and I have kind of talked about the Second Amendment precedent that's this court has kind of laid out. With Bruin last term, that is, and they ruled about like the historical kind of test. Any gun control law has to have some sort of foundation in this, in terms of the country's history and traditions. Now, this is an interesting one because it's kind of a follow-up. There's been all this like, litigation in different areas following that ruling. And this one deals with domestic violence protective order from a guy who isn't necessarily the I guess you could say the nicest guy out there, right? He's been charged with like shooting up places in Arlington, Texas. But aside from that, he was put under a domestic violence protective order for, I believe, assaulting his ex-girlfriend. And so he looked at the Bruin holding and said, this is before he was, I don't even know where his criminal case stands, but before being convicted of anything separate and apart, he's saying, just simply being under a civil protective order for domestic violence, it shouldn't cancel his Second Amendment right to possess firearms. And he did win in lower courts, right? The Fifth Circuit, I think, said had he been convicted, then that would be different in terms of being, his violent history. But like he wasn't. So here they said, no, he does have a Second Amendment right. And now the Supreme Court's going to review that. Tell me if I'm getting these facts wrong. Jump in here and tell me like, where does the court go with this? Because this is kind of one of like, I guess if the left, like the gun control advocates wanted to find like the best person to bring forward to the court to get some, sort of gun control measures on the books, this would be the guy, right? Yeah,
this is from the Second Amendment perspective, the worst possible case for a Second Amendment case. In the past, all the Second Amendment cases have been brought by plaintiffs. That is, they were people like Dick Keller and Otis McDonald and the New York State Rifle and Pistol Club, right? These are groups that handpicked their plaintiffs who are all law-abiding citizens. These are lovely people. And you got Mr. Rahimi who beat up his girlfriend and shot at a bunch of people, right? Mm-hmm. Not exactly what you want to be bringing to the court.
Right.
It's not surprising then that the Solicitor General rushed this case up. They didn't even bother seeking en banc, filed a cert petition in a week or two. Right? They moved quickly in this one to get this one argued as soon as possible. Now, there are other gun cases in the pipeline. Even one may be granted next month or so. A case called Range from the Third Circuit, R-A-N-G-E-V Holder, not there versus Garland, wrong H-E. And that one involves basically a white-collar offense, like Medicaid fraud or food stamps or just something that's non-controversial.
Mm-hmm.
The trick here is Mr. Rahimi's not been convicted of anything. He only had a restraining order, which is often issued ex parte, that is, without any sort of representation. And there is not really a tradition of disarming people who merely have restraining orders against them.
Right.
So if you take Bruin seriously, Rahimi should probably win. I think that's what the Fifth Circuit did. I've
talked to other court watchers who say exactly what you did, right? Like, to take someone's constitutional right away, usually you have to be convicted of something. So here he hasn't. Yet, like, you just kind of detailed, and I'm sure we'll hear even more about it during oral arguments, he's not like the best guy, right? And so do you think the breakdown of the court, there's going to be any justices that want to kind of, I don't know if I want to use the term bow to the public pressure, the idea of...
Never, Alex.
But do you know what I mean? I mean, like, it's a big deal. Like, you're right. I kind of think there would be enough justices there that would say, no, we're not going to take away a Second Amendment right from someone who doesn't have a conviction yet. But at the same time, we're talking about someone who, like the kind of best person that the gun control folks could bring forward to say this person shouldn't be armed, right?
Right. I mean, look, I'm looking at you, Brett Kavanaugh. Right. I mean, he's someone who seems to be at least receptive.
Right.
Yeah, I mean, Roberts and Kavanaugh, they concurred in Brewer and say, well, we don't really go quite this far. We still mean what we said in Heller about having, certain dangerous people and so on. So the only question is whether they watered down the Bruin test. And they say, well, we didn't really mean what we said. But I think it's unlikely that those two vote to affirm Mr. Rahimi's victory.
Mm-hmm. Okay, good. Well, interesting. I mean, there seems to be kind of a lot going on. We have a lot of First Amendment and Second Amendment stuff coming up. So I appreciate you kind of breaking them down for me. Is there anything I didn't ask you that we should have touched on? Did we cover the big ones?
Sort of lurking in the background, you mentioned the mifepristone case. That's sort of lurking in the background also.
Mm-hmm.
That's whether the approval of this abortion pill was permissible years and decades ago. So I think that issue might come up also this term.
You think they'll grant that one?
Yeah.
Yeah.
There's also the black horse, one thing I've been working on, which is the insurrection case. And if a state Supreme Court decides to keep Trump off the ballot, that issue can go to the Supreme Court really quick.
Right.
Bush v. Gore style, and something I've done a lot of work on. So
yeah, I know. You and I have talked about that. We probably should revisit it too once we see. I know they didn't take the one case. I think it was by the long shot GOP.
That was frivolous.
Yeah,
that's Adam Castro. It's a frivolous case, but there are cases brought by various left-wing groups. There's one in Colorado, one in Minnesota, and if a lower court actually rules to keep Trump off the ballot, the U.S. Supreme Court has to take it. And
so, go ahead, and for our readers, it's we'll just break it down real quick. There's a case pending in Colorado. Is that right? Is there any other ones that are currently?
Colorado and Minnesota, the big one. Another one, I think in Illinois. Michigan. Michigan was filed for
Okay. Yeah, and so they're basically saying the Constitution, the founders had said, nobody could, what's the wording, a rebellion or an insurrection?
They argue that because Trump engaged in an insurrection on January 6th, he's disqualified from the presidency.
Right. So they're trying to keep him off.
It'll take me an hour to go through them all. Mm-hmm. But I hope that none of the lower courts go down that road, because I think it'll be seriously negative.
Right, like let the people decide, I suppose.
Let the people decide. That's a good idea. Let people vote in elections.
But thank you so much for your time, Josh. I'll be in touch and hopefully have you back, and we can talk about what we think of all of these First Amendment and the Second Amendment case that we're going to be hearing soon. But then also, I'd love to have maybe just I should do an episode on this whole digital frontier, because I just kind of captivated by it. It's kind of just an interesting place to go, especially given that they didn't touch Section 230 during the Twitter and YouTube cases you mentioned.
Nope.
Yeah.
So I'm happy to do it, Alex.
All right. Thank you. Bye-bye. Thanks for tuning in to the latest episode of Court Watch. I'll have another episode in the coming weeks breaking down the court's recent arguments and what type of rulings we may see by the end of the court's term in June. If you have not subscribed yet to this podcast, please do so. And also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.